morning. She's an attorney with Chauvel Glatt and specializes in trusts, wills, and anything to do with that. And that's why we're all on the call today. So she's also a board member with the San Mateo Area Chamber of Commerce, and very pleased to introduce her. So Angel, you can take it away.
Thank you, Cheryl. Hi, good morning, everybody. Happy New Year. Thank you, Cheryl, for having me. And as Cheryl said, I am an attorney with Chauvel Glatt, and my main focus in this firm is estate planning, trust administration, and probate. And so along those lines, of course, I keep up to date on tax laws, both state and federal. And the most recent tax-related proposition that passed is Proposition 19, and that's why we're all here. So I'm going to do a screen share to start the presentation. And as usual, if you've been to any presentations with CPAs or attorneys, we have to start with a disclosure. So just bear with me, and then we'll get right into the material. Okay. So Proposition 19 and the parent-child transfer. So as for the disclaimer, essentially, no information presented in this presentation constitutes legal advice, nor is it intended to be fact-specific, as there may be occasions where me or Chauvel Glatt represents clients who may be adverse to your interests. Discussion, questions, or any program content related to this webinar cannot touch upon any fact-specific matters. Attendees should consult with knowledgeable legal counsel to determine how applicable laws pertain to specific facts and situations. And to further be further advised that these materials are based on the most current information available, since it is possible that laws or other circumstances may have changed since this presentation. Please consult with legal counsel to discuss any action you may be considering as a result of attending this webinar. Attendance at this program and or receipt of these materials is not intended to create, nor does it establish an attorney-client relationship. Okay. So what are we talking about today? So obviously, Proposition 19, and what is it? And the second portion, how does it affect you, mainly you / your children? And what can you do now to protect assets and your assets and your children? Essentially, Proposition 19, the full term of it is the Home Protection for Seniors, Severely Disabled, Families and Victims of Wildfire or Natural Disasters Act. Proposition 19, when passed, had several parts. The first part being that property taxes, there's additional protection for seniors, the disabled, and victims of wildfires and natural disasters. There was also an expansion of Prop 6090, which is when people of a certain age, I believe 50 and 55 and over, can carry their current tax bases when moving to a different county. And the last portion is revocation of Prop 58 and Prop 193 with limited exception for family or personal residence. For the purposes of today, we're only going to focus on the last portion, which is revocation of Prop 58 and Prop 193. Okay. And before I go deep into the material, just note that, this particular webinar, we're only here for half an hour. And so my goal in creating these slides was to give you kind of a crash course on this one component of Proposition 19, what it means to you, what it means for any family, and some solutions that you have that you can share with your family or maybe your clients. Okay, so let's start first with Proposition 58, okay, and what that did. And technically Proposition 58 193 is still in effect until Proposition 19 kicks in. Okay, so Proposition 58, which was effective November 6th of 1986, was an amendment to our Constitution, California Constitution. which excludes from reassessment transfers of real property between parents and children and vice versa. What that meant was after 1986, up until now, before Proposition 19 goes into effect, when a parent transfers a primary residence to a child, regardless of assessed value or market value, the receiving child does not, there is no reassessment of property taxes. In addition, the parent who owns the property, if that parent has, let's say, an investment property or a vacation home or Airbnb or second home, that original owner, the parent, can transfer that additional property to the child because that parent has an additional $1 million limit, okay, on transfers of non-principal residence property. And that $1 million is based on assessed value. Okay, so very common scenario, let's say mom and dad live in Burlingame. That's their primary residence. Mom and dad also own a rental property in San Mateo. If that rental property, let's say, is assessed at $500,000, which also a very common scenario if the parents bought it 30, 40, or even earlier, okay? If that assessed value is under $1 million, that parent or parents can transfer that additional investment property to the child, and that receiving child is not going to be reassessed for property taxes. Okay, so Proposition 58 was very favorable, is still very favorable for really, transfers of property in the Bay Area because our appreciation is so high. Okay, now let's dive into Prop 193. So Prop 193, pretty similar to Prop 58, except, okay, came about 10 years after, and it's a constitutional amendment, okay, which extended or excludes the reassessment transfers of real property from grandparent to grandchildren, provided that the parent of the receiving grandchildren are deceased. So essentially, you can skip a generation, okay? But in skipping that generation, the parent that's in the middle has to be deceased. Both of these propositions, 58, 193, they expire when Proposition 19 takes effect, which is on February 16th of this year. Okay, so then what is Prop 19 and how does this affect parent-child transfers? So Proposition 19 created the following changes. First of all, it completely eliminated the lifetime $1 million non-primary residence exclusion. What does that mean? After February 16th of this year, if a parent transfers to a child an investment property, commercial building, Airbnb, second home, that property will be fully reassessed completely. Okay. Second component, it eliminated the primary residence exclusion unless the child receiving the property from the parent resides in the primary residence. And even if the child resides in the primary residence, okay, the child assessed value is then determined based on whether the property at the time of transfer is greater than the parent's assessed value by more than $1 million. In other words, if the value of the property at the time of the transfer exceeds the parent's assessed value by less than $1 million, then the child takes the parent's assessed value. If the value of the property at the time of the transfer exceeds the parent's assessed value by more than $1 million or more, then the child's assessed value is the current value of the property less $1 million. Okay, that was a lot. So let me give you two examples. Example one, Mother A has a personal residence in San Mateo that has a fair market value of $950,000. Okay, the assessed value for said residence is $100,000 because mom bought it a long time ago. And therefore, the annual property taxes is only $1,290 a year. Under Prop 58, which again expires when Prop 19 goes into effect, under Prop 58, Mother A can transfer the residence to her child, and the child would be completely excluded from reassessment. Okay, and the child is not required to move in. Similarly, under Prop 58, let's say Mother A turns this residence to an investment property. The mother can still transfer the residence, the investment property, to her child, and the property taxes will continue to be at a mere $1,200 a year, plus the annual adjustments, because the property at issue has an assessed value of under $1 million. Now, come February 16th of this year, when Prop 19 goes into effect, when Mother A transfers the personal residence to her child, the receiving child, one, must live there. Okay, you have to live there. And in this scenario, the child would be excluded from reassessment because the fair market value is below the parent's last assessed value, which is 100 grand plus $1 million, because the home is only worth $950,000. If in my scenario, the child uses this residence as, let's say, investment property and does not move in, then that child will face full reassessment of the property taxes. Okay, let's go on to another example. Okay, Mother B has a personal residence that has a fair market value of $3.5 million. So today it's worth $3.5 million. The assessed value for said property is $500,000, which means the property taxes every year is about $6,450. Under Prop 58, Mother B can transfer this property to her child and it would be completely excluded from reassessment. And the child is not required to move in. And even if Mother B turns this $3.5 million property to an investment property, still she can transfer this property to her child and the property taxes would still be at $6,450 with annual adjustments because the subject property has an assessed value of under $1 million. Okay, so very, very favorable laws. Okay, now under Prop 19, okay, which would supersede everything that I just talked about with Prop 58 come February 16th of this year, the child under this example has two scenarios. Scenario one, the child receiving this property moves in. Okay, and if the child moves in, it's going to be a partial reassessment. So what you would do, what the county would do is you would look at the current tax basis, okay, which is $500,000, and you would take the current market value minus the current basis plus the $1 million exclusion because the child's moving in, and you get the amount of 2.5 million, which would be what the county would assess the child at in terms of the value of this property. And you multiply that by about 1.2%, which is the general tax rate. And so the child, upon receipt of this property, even if he or she moves in, their annual property taxes would increase to about $32,250 a year. Okay. The second possible outcome, the child takes the property and does not move in. Well, if you don't move in, the county is going to reassess you 100% value of the property. And so easy math, you take 3.5 million, you multiply that by the annual tax rate, and your annual property tax is going to be about $45,000. Okay, so very, very, very large jump, okay, from what the parents paid and what now the child is subject to pay upon receipt of this property. Okay, this would also be, so scenario two would also be the same outcome if the parent, if Mother B transferred a investment property, okay, because under Prop 19, investment properties from a parent to a child is completely reassessable. Okay. So, okay, that was kind of my crash course on Prop 19. So now that you know what could happen, what can you do about it now to protect your assets and children? Okay, well, you can conduct transfers now before February 16 of 2021 because Prop 19 is not effective until then. And there's a couple ways you can do it. Way number one is you can give the real property in its entirety to the child. You can transfer the property to a child in a way in which the parent and the child or children become original transferors, otherwise known as joint tenants. Okay. And way number three is you can transfer a majority interest to one child or collectively a majority interest to multiple children and hold that interest with your child in an LLC. Okay. And then upon the death of the parent's LLC interest transfers then to the child. Okay. Similarly, up top, I'm going back real quick to joint tenancy. Joint tenancy in California by default has a right of survivorship. And so when the parent dies, the parent share automatically transfers to the child. And the last solution is you can create an irrevocable trust with a general power of appointment. Okay. And I put this here because when Prop 19, even before Prop 19 passed, first of all, I saw it on the ballot and I saw the language that it contained. And I had a feeling that it was going to pass. And so at that time, I think it was around October, I started making my calls to other attorneys in the area. And I said, if this passes, what is your solution? What are your ideas? And consistently before and after Proposition 19 passed, there was this idea of creating an irrevocable trust with a general power of appointment retained for the parent. Okay. And so a lot of attorneys, I imagine, have never done this route before for the purposes of mitigating Prop 19 because Prop 19 just passed. Okay. Whereas the above three solutions, gifting, transferring, to become original transferors, or holding a property in an LLC or legal entity, those are pretty much old tools in any estate planner's box. Okay, but those are all solutions that you have to mitigate Proposition 19. But you have to do it quickly. You have to start now or advise your clients now to seek legal counsel to look into this, because you can guess that counties are being bombarded with deeds to effectuate transfers now before Proposition 19 goes into effect. Okay, before you make any transfers, here are my recommendations. Okay, first of all, if this is to help yourself or your children, talk to your children. I've had multiple calls with clients in the past 2 months where, they call me panic with Prop 19. What are my kids gonna do? They're never gonna be able to stay in this area. They're gonna have to move. Well, my first advice is, okay, yeah, that's very possible. Not a lot of people can afford property taxes that amount to $20,000, $30,000, $40,000 a year. But talk to your children. What if they don't want to live in the house? What if they don't want to be a landlord? What if they don't want to invest in real property? What if all they want is at the time of your death or the parent's death, sell the property? Okay, because at that time, most of the time, our clients' homes is paid off. Sell the property, take the net proceeds, and then go off and do their own thing, buy their condo somewhere or buy somewhere else, wherever they want to do to plant themselves. So first thing is talk to your children. Second thing is, once you've talked to your children and you realize, okay, this is what we need to do, consult an attorney, of course, and your CPA, okay? Because as with anything dealing with sort of tax shortcuts, when you do one thing, it always triggers another. When you gift property to your kids now, you have to file a gift tax return. You potentially are giving up a large step up in basis and therefore can trigger large capital gains down the line. These are all very, very important issues that you need to understand before you make transfers. And if you want to understand them, do so now, because Proposition 19 is effective again on February 16th of 2021. Okay. So with that, I have the disclaimer again, which I'll let you take a look at. And while you're doing so, I imagine Pauline may have some questions she's gathered, and I'm happy to answer any questions.
Actually, Angel, there are no questions in the chat box.
Because it was an overload of information.
Yeah, maybe
I
they're
think we're in shock.
yeah, we're in shock. And then do I have permission to send out the slides?
Of course, yeah.
Okay, so that retracted. I did put it in the chat that if you have not registered and somehow got the link to join us, welcome. But I also need your email so I can send the slides out to you. So
And
make sure you register.
There's actually a couple of questions now in the chat, Pauline.
Steve has one. How long do kids have to live in the house?
That's a good question. I'm gonna say for now, indefinitely, because yeah, that's a good question. I can look into it, Steve, and if you want to email me or give me a call, I can get back to you. But I do know that at the outset, you know, because if you live in the home, right, and if you move out of the home
for rental purposes, maybe.
right, for rental purposes, you know, really the county, frankly, they're not going to know about it, because only people that are going to know about that is the IRS, right? If you're reporting on your income tax. And it's not like the county goes door to door knocking to see, hey, you still there? So I would assume that if so long as you moved into the home at the outset, your property taxes should be secure. Simply because just knowing the county, once you have that homeowner's exemption locked in and you prove to the county that you moved in after receiving the property, that's it. There's no, you know, ongoing 2-year check-in or 5-year check-in.
Got it.
Okay, Robert Rossi, if the parent and the child bought the property together, is it exempt?
It depends, okay? Because in that scenario, we're defaulting into the joint tenancy rule. So the joint tenancy rule, there's what I call like a quirky rule in California, right? Where if two people go into a property or hold ownership as original transferors, meaning the original owners, and one of them dies by default of the right of survivorship, right, transfers to the surviving joint tenant, also the surviving original transferor, the county does not see that as a change in ownership. It's a quirky rule to me because I don't see how it's not a change in ownership, but that's how they function. And so under that rule, that's why the original transfer legal avenue works for Prop 19, because if there's no change in ownership, you can't get reassessed. Okay, so to that question, it depends on how title is held between you and your child.
Okay, I had a comment from Marta. She said she has reached out to the assessor's office and they keep saying it's effective April 1st, 2020. I don't know what that one is.
Yeah, so it would be, I think well, first of all, it probably would have been April 1, 2021. And I believe she's referring to the extension of Prop 6090 under Proposition 19. What we're talking about today is the parent-child transfer and how that's affected by Proposition 19.
Okay.
What happens if you actually have more than one child? I mean, we're talking about one child moving into the property, but what if you have 2 or 3? I mean,
Yeah.
Are there any specific rules about that?
No, the county doesn't care that siblings more than likely later in life don't ever want to live together. They don't. And so, yeah, I mean, that's one of the discussions that I often have with my clients. And, you know, it's you have to kind of, again, talk to your kids, right? Because what if there's that one child who's like, Mom and Dad, I really want to raise my kids here. This is my house, my family home. I really want to live here when you die. Then maybe that child should receive the property now, and you can offset the other children's inheritance based on provisions of your family trust. The tricky part though, right, is a lot of families here, their main wealth is held in one property, right?
Right.
And then that's when, really Proposition 919, to be frank, it just forces parents to, or children to have to sell and divvy up the net proceeds, because either you live together or you own together as joint tenants or tenants in common with siblings, which frankly, often it doesn't work. And you pay the higher property taxes. So, this is a proposition that really that's kind of one of the triggers, right? You're basically forcing families to have to sell their home, which at the end of the day, if you're getting, 2 million cash for your parents' home in Palo Alto or Atherton, 2 million each, right? Depending on how many siblings you have, not a bad deal.
Mm-mm.
Yeah, so we have another question from Heina. And how soon do the kids have to move into the residence and make it their primary property?
I believe it's within, it's either I believe it's within a 2-year period. Don't quote me on that, because a lot of my research under Proposition 19 has been sort of, okay, let's not think about really how long you have at the back end. Let's think about now. What can you do now to mitigate the higher taxes down the road? So don't quote me on that, but I believe it's within 2 years.
Okay, and from Kendra, what if rentals are already in an irrevocable bypass? What is two rentals
can
in a
say it.
bypass? Yeah, Kendra, you could do it.
Two questions actually, Angel. So if a child and parents are on a deed as tenants in common, right now, by just all of a sudden having them convey their interest to themselves as joint tenants, that would not work, correct?
I'm sorry, I asked the first part of the question again.
Yes. If currently child and parents are on a deed as tenants in common for an existing property, to now have them convey their interest to themselves as joint tenants, that will not work because they're not.
It will work.
Okay,
It
that
will
will.
work.
They go
Yep.
ahead and convey.
Okay. It will work. And actually, Kendra, you bring up a good sort of segue into that particular legal avenue. Is that's the way you would do it, right? If you wanted to become original transferors, is, let's just say, for easy example, let's say me and my parent, right? The home is in my parents' name and they want to shelter me against Prop 19. The first thing we would do is she would deed the property to me 50% as tenants in common. And then collectively, we would deed the property to ourselves as joint tenants, thereby becoming original transferors.
Okay, got it.
That's how that rule works.
Okay, so even now, go for the tenant in common solution and then go for the joint tenants solution.
Yeah, you
right?
have to. Yeah,
Okay.
because then you become, and again, for me, it's a quirky rule because and if I'm thinking through the lens of a legislature, it doesn't make much sense to me, but hey, it works. So
Okay.
the original transfer, that rule, it works.
And then the February 15th date, if deeds are executed, notarized, and sent, but have not yet been filed, is that okay, as long as the deeds are dated prior to February 15th?
So that's a common question that I get. And before I answer that, everyone on this call, just be aware that, anytime a proposition is passed, the legislatures don't need to codify that into administrative law until now, right? So even the assessor's office, they're not going to get the manual of how to really do this until later in January, which is why if some of you have called the assessor's office, they tell you, ma'am, sir, we don't know, I'm sorry, we're waiting for the California Board of Equalization. And so because of that unknown territory, my cutoff date for anyone to reach out to me to have a consultation or prepare documents or deeds for them is going to be around January 20th, because I'm not taking the risk of having something signed on Valentine's Day.
Yeah.
And then for it to then come back and say, oh, you didn't meet the mailing deadline or this or that. So the sooner the better. Now, by the book, yeah, it's not effective until February 16th, but my personal cutoff date is much earlier than that.
Okay, thank you. And do you think so if by conveying it to kid and parents as joint tenants, but if right now, let's say child has 1/3, parents have the other 2/3 as community property, is there going to be a proportional problem? Like if the proportions are not exactly a third, a third, a third, let's say child has 50%, parents have another 50%. If they all convey their interest to themselves as joint tenants, will that create a problem at that point? Because joint tenancy might see it more like a third, a third, a third.
Yeah, so for me, joint tenancy, the way I view it is that it's equal between all the transfers, right? And not like 2/3 and 1/3. That's the way I envision joint tenancy.
Okay. And then the other thing is if someone already has 2 rentals in a bypass trust, spouse has already passed away, and they're looking for solutions of how to deal with those rentals already in that bypass trust, and there's not the general power of appointment for the surviving spouse in that, are they kind of up a creek at that point?
Yeah, because irrevocable trusts are irrevocable by definition, right? And
Right.
so you would have to either come through the trust and see if there's some loophole you can get around, or you have to revise it by going into court. Generally speaking, those are the 2 outcomes. Anytime a client wants to revoke, I'm sorry, amend an irrevocable trust.
And there wouldn't be time to go to court.
Does anybody else have? No,
Thank you.
you're welcome.
Angela, could you repost your contact information so I could get
I
that?
can, yes. I think I was
Please.
sharing it. Let me
Please.
do it again.
Yeah, you shared it for a second, but it went quickly, so I just wanted to make sure I grab it.
Yeah, of course. Thank you for asking.